Welcome to Mayor Brown's Tech Talks podcast. Each podcast is designed to provide insights on legal issues relating to technology and IP transactions and keep you up to date on the latest trends in growth and innovation, digital transformation, IP and data monetization, and operational improvement by drawing on the perspectives of practitioners who have executed technology and IP transactions around the world. You can subscribe to the show on all major podcasting platforms. We hope you enjoy the program.
Hello and welcome to Tech Talks. Our topic today is strategic considerations for data privacy compliance in tech transactions. I'm your host, Julian Dibbell. I am a senior associate in Mayor Brown's technology and IP transactions practice. I'm joined today by my colleagues Arsen Kourinian, Josh Cohen, and Megan von Borstel. Arsen is a partner in Mayor Brown's Los Angeles office and a member of the Cybersecurity and Data Privacy practice. Josh is an associate in the Cybersecurity and Data Privacy practice, the technology and IP transactions, and the corporate and securities practices in our Chicago office. Megan is a mid-level associate, also in the Chicago office, and a member of the firm's litigation and cybersecurity and data privacy practices. Okay, Arsen, I think the average person, to the extent that they know anything about data privacy laws or think about them, they think about them in the context of direct breaches of those laws, where some kind of personal privacy violation has actually or allegedly occurred. A data breach at a credit reporting agency, say, or improper data sharing by a social media company. The average technology lawyer, I think, is probably more sophisticated than that and knows that even before you get to that point, companies can run afoul of data privacy laws just in how they enter into a particular transaction with another business, right? But I don't think we're always clear on when and how those laws are implicated in that context. So let me just ask you straight up, how do we know whether data privacy laws are triggered in a tech transaction?
Great. Thanks, Julian, and hello, everyone. Yeah, I think the initial question is how are these laws triggered? And they're triggered whenever personal information is either received or disclosed by one of the parties that is subject to the deal. Now, when you think of personal information, it's important to understand what it exactly means. It's a very broad term. So some common ways you would think of personal information would be things that maybe directly identify someone, such as an email address or a name or a phone number. But the reality is the way these data privacy laws define personal information, it goes well beyond that. And so it could include things that might indirectly be linked to information that identifies you, such as someone's IP address, device ID, or for example, if it's an ad tech deal where there's going to be cookies placed on a website, they can monitor somebody's usage of a website. Now, in those instances, you may never know who that person is. You might never know who the person is affiliated with an IP address or a device ID, but those data sets in and of themselves are actually personal information. And so whenever personal information either is being received by you as a party to the agreement, or you're going to be disclosing or making available personal information to another party to the deal, it is important to understand what data privacies are triggered and what the implications are and what terms you would need in the contract for that.
Okay, but so laws are triggered, but what laws, right? I have heard there are over 150 data privacy laws around the world. How do we determine which countries' data privacy laws are triggered for compliance purposes? Megan?
Well, Julian, there is no one-size-fits-all solution to this, unfortunately, but we do have some guideposts that help us out. So for starters, it's helpful to understand whose personal information is involved here. For example, if there's EU residents or US residents data that is being processed. It's also helpful to know where the data is actually being stored. So if it's in a cloud in Brazil, or if it's located in Canadian servers, for example, those kind of questions typically give us an idea of which of these data privacy laws are going to be triggered. And then that requires us to address certain country-specific requirements. I'm talking like cross-border data transfers, processor service provider terms, and then we take it from there.
Okay, and then besides countries, we have within the U.S. we have state privacy laws to worry about, right? I've heard there are some U.S. state privacy laws that are kicking in next year. Which of those should businesses have on their radar?
And you heard right, there's 5 US states that have passed pretty comprehensive privacy laws that are going to become effective at various points next year. So the states to look out for are Virginia, Colorado, Utah, Connecticut, and then also California. Now that might seem like a lot, but fortunately many of these laws have overlapping requirements and consistent regulatory schemes, typically modeled after Europe's General Data Protection Regulation, also known as the GDPR. But there is one law, California's law, the California Privacy Rights Act, the CPRA, that's quite different from the rest.
How so? What makes it different?
For one, the CPRA does not as closely track the GDPR. So under the CPRA in California, we're looking at an opt-out model. The consumers have the right to opt out of their processing, as opposed to an opt-in consent model under the GDPR and those other state laws. So it's going to create a few unique regulatory obligations for businesses. The other reason it's pretty different is it's considerably broader than the other state laws. So the CPRA is currently the only state US privacy law that's going to apply to employee data, HR data, and business-to-business data. Under its predecessor, the CCPA, there was an exemption for both of those types of data, but that's set to expire on January 1st, 2023. So we're seeing a lot of clients, a lot of companies revamp their approaches to their compliance with this law.
Okay, well, if a business is evaluating whether they are subject to the CPRA, what are the triggers that could apply?
Well, if you are a for-profit company and you do business in California, then it's important to take a close look at the threshold requirements. So at a high level, the CPRA regulates 4 different types of entities. We've got businesses, service providers, contractors, and third parties. Now, business is the relevant one under the CPRA if you're a data controller. So you're the one who's determining why the data is collected and how it's going to be used. And a company can qualify as a business if they're a for-profit entity that does business in California, and then they meet one of 3 critical thresholds. So that's going to be 1, do they have gross revenues in excess of $25 million a year? Or do they buy, sell, share that personal information of at least 100,000 California consumers or households? Or 3, they derive 50% or more of their annual revenue from selling, from sharing that California consumer personal information. If you meet any one of those 3 triggers, then you would qualify as a business and be subject to specific requirements under the CCPA and the CPRA.
Okay, so that's just the businesses, the first category of entities. What about the others that you mentioned?
Right, so you've also got those other buckets. Service providers, those are the companies that are processing information on behalf of another business. They could also be subject to the CPRA and other state laws. And you're going to have specific terms in your contract as a vendor in that case. There's also third parties, also typically process the information or they share the information downstream. They're going to have fewer restrictions on how they use that data. Okay, so a lot going on there in California. What about outside the United States? What are we seeing? Fewer developments, fortunately. In Europe, the prevailing privacy law remains the GDPR. Post-Brexit, we've got the UK GDPR in the UK. So while the GDPR, it's not as new as these US state privacy laws, there are still interesting regulatory developments in that space. Most notably, we're seeing a lot of scrutiny around the ad tech space that Arsen mentioned previously. Those use of cookies and digital advertising has led to 8 and even 9-figure fines from data protection authorities in the past year or 2 for failure by big tech companies to fully disclose their advertising cookies and give consumers their informed choice around their data. So for these laws, I mean, what would trigger a company being subject to the GDPR, the UK and the EU? Well, in that case, we'd be looking at mirror triggers for the GDPR and the UK GDPR. So a company can become subject to those laws in one of two ways, really. The first is if they have an established presence in the EU, so a branch or an office, regardless of where the data they're processing is located. Or the second way is if they're a company that's not necessarily in the EU, but they offer goods or services, either paid or free, to individuals located in the EU, or otherwise monitoring the behavior, then they're going to become subject to both of those laws.
Okay, got it. So we've sorted through what kind of personal information is involved, and then which countries' laws are triggered. So now, you're sitting down to do your transaction. What provisions are you going to need to include in the agreement to address these laws? Josh?
That's a great question, Julian. So for starters, we need to know the nature of the relationship between the parties. So the first party to know is the data controller, which is basically the entity that owns or makes decisions about the personal information in its possession. And there are transactions where there's a data controller who's transferring personal information to another party, which will essentially have free reign over that data for its own usage and purposes. So the recipient here would be another data controller, or what we call a third party, depending on the terminology under the given data privacy law. And in these scenarios, there are often limited terms that need to be included in the agreement. We can call these controller to controller terms. So for the contract terms, you would want to include representations that both parties will comply with applicable data privacy laws in their collection, processing, and use of the personal information, and that both parties will cooperate and assist each other with discharging their legal obligations. There are other provisions to consider as well, like indemnification and some reasonable data security terms and breach notification, to name a few. But it's typically these terms are more limited in this controller to controller data sharing scenario. Also, as we'll discuss a little later, if the agreement has a cross-border component, some countries have specific requirements for cross-border data transfers, so those issues would need to be addressed as well.
All right, so that's first, you're talking about controller to controller relationships and what needs to go into that kind of an agreement. I mean, what I see more in my practice is where it's a data processing agreement. When did those come into play?
Yes, we frequently negotiate the data processing agreements, or DPAs, in the context of tech transactions. So in addition to the scenario in which there's two data controllers sharing personal information, another common scenario is where the data controller transfers personal information to a vendor, supplier, or a service provider in order to receive some service, such as cloud storage or software as a service, payment processing, you name it. In that situation, the recipient of the personal data is called a data processor or a service provider, depending on the lingo and the applicable data privacy law. So before a processor performs any operations on that personal data on behalf of the controller, various laws require those parties to enter into a contract that establishes the details of the processing, along with certain required obligations. So this contract we call the data processing agreement, or an addendum, depending on how it's used. And this DPA sets out how personal data is going to be stored, protected, accessed, and used by the processor. So Article 28 of the EU's GDPR sets out several required components for DPAs that you're likely to see. These include the processor will follow the controller's instructions when processing personal data. All persons handling personal data are subject to a duty of confidentiality. There's a reasonable data security requirement. The processor must cooperate with the controller to comply with privacy laws and obligations. The processor may be subject to audits. The processor needs to flow down the same level of protection in the DPA with any agreements it has with sub-processors. And at the end of the services, at the conclusion, the processor needs to return or delete the personal information of the controller. And generally these GDPR tailored DPAs are sufficient for most of the US requirements. But there are some additional terms that you need to impose on the recipient entity if you want that entity to qualify as a service provider, a defined term under the California privacy laws. And generally, the recipient then cannot sell or share the personal information, and the recipient cannot use the personal information for really any purposes other than discharging their obligations under the services.
Okay, well, that's a helpful set of provisions to keep in mind. You mentioned that we were going to talk about what happens when there are cross-border considerations where data is crossing borders between one party and the other. What about those?
Of course, that's another great point. Cross-border data transfers, that's probably one of the most dynamic legal issues in the data privacy field today. As we previewed earlier, in an international transaction, you may have to also consider, in addition to your DPA, you may have to also consider cross-border data transfer issues and the appropriate legal mechanisms for handling these. So cross-border data transfers are a topic deserving of an entire podcast on their own, but essentially the EU and the UK have said that a data transfer outside of their territory is only automatically legally permissible to recipient countries that provide for an adequate level of data protection. And the EU and UK have provided each other and a few other countries with such an adequacy decision. But notably, the US has not received an adequacy decision. There may be one in the works, but that's another topic. So for countries that are not deemed adequate, like the United States, you're transferring data from the EU or the UK to an inadequate country, you'll need to rely on a legal transfer mechanism. And the most common of these is the standard contractual clauses, commonly referred to as the SCCs, that are pre-drafted model clauses that you just simply attach to the end of your data processing agreement.
Very helpful, Josh. Thank you. Thank you, Megan. Thanks, Arsen, for your insights today. Listeners, if you have any questions about today's episode or an idea for an episode that you'd like to hear about anything related to technology and IP transactions and the law, please email us at techtransactions@mayorbrown.com. Thanks for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.